For some time, we Americans have watched as the federal government has become bigger, less efficient, and more intrusive in our lives. It has created an unfair tax system, spends money recklessly, and incurs debt at an accelerating rate. It imposes regulations which affect virtually all human activity. Members of Congress pass bills without giving us the opportunity to become informed about them, and even worse, many do not read the bills themselves.
But we have to pass the bill so that you can find out what is in it away from the fog of the controversy.
The President usurps Congress's power to legislate by changing laws by administrative fiat. He selectively enforces federal laws and sues states to stop them from enforcing their own. We have government agencies which spy on us and government officials who lie under oath to Congress and the American people without any repercussions. We have a Supreme Court which diminishes private property rights and upholds a federal mandate that Americans purchase a government-prescribed health insurance policy under the guise of calling it a tax only after it was passed. The expansion of federal power has developed incrementally and inexorably over the last century regardless of the party in power. The power of the federal government seems to intoxicate almost all entrusted to serve. Experience informs us that changing representatives is simply not sufficient to change the dynamics of our government. The Constitution's framers foresaw this possibility of a runaway national government. Americans across the United States are joining together to defend their rights and the Republic. We are doing this through the Convention of States Project, an effort to compel Congress to call a Convention of States for the purpose of limiting the power of the federal government. Our effort is gaining momentum. As it does so, some groups are making unfounded claims about Article 5 of the Constitution and intentionally creating fear about the convention process. Here, objections from the John Birch Society and Eagle Forum representatives are considered. It is argued that the Constitution must be revered, that it isn't the problem. The politicians, they say, are the problem.
The only thing the matter with the Constitution is that the courts don't obey it.
We're going to talk about a propaganda campaign that is going out through the entire conservative movement like a prairie fire. And it concerns the Constitutional Convention movement. The John Birch Society has been involved for years, the linchpin, if you will, of getting rid of Constitutional Convention calls in state after state across the country. Because in that we see a very dangerous thing happening due to the precedences of constitutional conventions.
This argument has some appeal. This suggests that we are failing to fix what is really broken and risk breaking what isn't broken. We know from historical records that the framers intentionally provided for a convention of states as a separate and distinct method for amending the Constitution for precisely the reasons we propose one now. The federal government has amassed too much power, and it cannot be expected to voluntarily relinquish that power on its own accord. The framers recognized there could arise a need to recalibrate the balance of power ordered by the Constitution. Exercising the right to apply for a convention to amend the Constitution respects the framers who so ardently argued and voted to provide it to the states. This right is itself a check and balance considered necessary for the preservation of our federal system. Failure to exercise the right simply compounds the imbalances that exist and contravenes the intentions of the framers. Who can deny that the Constitution has been rewritten over time, slowly and surreptitiously, even without formal amendment? It is said, however, that we don't have leaders of the caliber of the framers to trust with amending the Constitution.
The Constitutional Convention that gave us our present Constitution had George Washington as president, and great men writing it, like James Madison and Ben Franklin and Alexander Hamilton. I don't see any George Washingtons and James Madisons around today.
On the other hand, we are told that the solution is to elect the right people. So which is it? Do we have statesmen who can be trusted or not? If they exist for us to elect to federal offices and appoint to the bench, why then do they not exist for an amending convention? Relatedly, we are told, politicians don't obey the Constitution now, so why would they obey it once amended? As just mentioned, we've been told that the solution is to elect better politicians who, presumably, would appoint better judges. By making this objection to the convention, that we can't rely on politicians to do right any more in the future than they do now, opponents seem to concede that elections alone are an inadequate remedy now and in the future.
If people are ignoring the Constitution now, the law of the land, what makes anyone believe that if they have a new Constitution or new amendments to solve problems, that Congress, the President, the Supreme Court, the Army, etc., will listen?
We are told that there are other, less risky means to deal with the imbalance of power. For judges who abuse their power, there is impeachment for bad behavior. The fact is, however, that in the entire history of the United States, only one justice of the Supreme Court, Samuel Chase, has been impeached by the House of Representatives. He was acquitted by the Senate and continued to serve on the court until his death. Also, this idea ignores the fact that the impeachment power rests with a branch of the federal government. This proposes that we encourage one branch of the federal government to become more activist so as to limit the activism of another branch. Our experience tells us, however, that the most likely result would be Congress using impeachment to remove originalist justices in favor of more activist ones. Even if that was not the intent, it could be the result. Had Justice Roberts been removed for his decision to uphold Obamacare, President Obama would have been the one to nominate his replacement. Another remedy some opponents urge is state nullification. Nullification is controversial. Even if it has merit as a constitutional matter, it has been largely circumvented by the federal Supreme Court's assertion of authority as the final arbiter of what is and is not constitutional. Additionally, opponents of a convention of states distrust state legislatures and cite Common Core and Agenda 21 as examples of states being co-opted by the federal government through federal funding of these programs. Yet these same opponents seem to believe that state legislatures will have the wherewithal to declare void federal laws which they believe are unconstitutional, regardless of Supreme Court pronouncements to the contrary. As bad as things are, opponents claim there can be a runaway convention which rewrites the Constitution. Any such risk would be very concerning. This claim by the opponents to an amending convention is intended to make us reconsider the costs and benefits of our course of action, because no amendment is worth risking destruction of our Constitution. On this point, however, the opponents have only fear and no evidence to support their opinions. This is what they claim.
Article 5 clearly gives the power to propose amendments exclusively to the convention. This is explicit in the wording of the article. Congress calls the convention while deciding other details, such as where the convention may meet, how delegates are to be paid, and how many delegates there will be, and how they are chosen. Note that nothing in the Constitution requires nor guarantees that delegates to a con will be elected by the people. Congress is given a free hand to determine the method of selecting these delegates. Congress itself could choose to make the appointment of delegates. Congress could provide that the state legislatures appoint delegates. In short, Congress is given a blank check to determine how convention delegates are to be chosen.
Anybody who tells you he knows what's going to happen simply doesn't know what he's talking about, because there are no other rules out there, and if they were, the convention doesn't have to pay any attention to it. You can go on my website, eagleforum.org, and you can see a very important letter from former Chief Justice Warren Burger, who wrote, Congress might try to limit the convention to one amendment or to one issue, but there is no way to assure that the convention would obey. The convention could make its own rules and set its own agenda. Now, how would the delegates, there's so many things we don't know. How would the delegates be elected? How would they be apportioned around the state? There are some people who want the convention to consist of each state has one vote. That's the way the original Constitutional Convention was.
Is it possible that a majority of those commissioned to represent their respective states could go rogue, disregard their instructions, and act contrary to their state's application? Theoretically, it is possible, just as it is possible that a President of the United States could suspend the Constitution and declare martial law if we don't act. Choosing to act or not, therefore, based only on extreme possibilities related to one choice versus another, is simply unfair and unreasonable. We should also consider the actual flouting of the law now as an example of what will continue to happen if we do nothing to arrest a runaway federal government. Respecting the applications, we are told that the states can't limit them to particular subjects. They say every application for a convention must necessarily be construed as a general one, and any convention called will not be confined to any particular subject. But consider the fact that 49 of 50 states have already applied for a convention to be called at some point in our history. Most applications contain an express purpose for which a convention is being sought. Given these circumstances, either Congress is violating the Constitution by failing to call a convention notwithstanding the divergent purposes of the state applications, or Congress tacitly recognizes that the states do have the power to limit the scope of their application. If one believes that Congress is violating the Constitution, then we already have a constitutional crisis of sorts which only adds weight to our argument for the necessity of a methodical, coordinated effort now for a convention. As a practical matter, only the states can force a convention if Congress refuses to act. Where the states are pursuing divergent interests, such coordination for convening a convention is unlikely, and Congress will not be challenged, whether it is acting lawfully or not. As to other details, such as the number of commissioners and how they will be chosen, we know from other conventions between states and state constitutional conventions that the states make those decisions. In all conventions between states, each state is equally represented regardless of the number of their respective participants. In theory, this practice could be changed, but it would require unanimous consent by the states, which is highly unlikely. It has never been done. Article 5 itself does not expressly give any power to Congress regarding a convention of states except to call it upon application of 2/3 of the states. It sets the time and place. Thus, nothing in Article 5 supports the opponent's claim that Congress will decide the composition or course of the convention. Again, any such interpretation would be inconsistent with the very purpose for which a convention of states was added to Article 5. Chief Justice Burger, who died in 1995, was addressing the idea of a constitutional convention. He warned that Congress could try to limit it, but there was no certainty it could. To the extent his opinion applies to an Article 5 convention, Chief Justice Burger supports our view that Congress does not and should not get to regulate it. When evaluating Chief Justice Burger's opinion, it is important to note that his letter was written in 1988, over 25 years ago, while Ronald Reagan was president. Clearly, much has changed since then to compel reasonable people who may have once opposed a convention of states to now support it.
Now, some people try to tell you, we've got a great safeguard, because whatever they do will have to go out to the states for ratification and would have to be ratified by 3/4 of the states. Well, maybe if the Constitution can amend anything else, they could amend that.
Regarding the terms for ratification, opponents say a convention could change the requirements for ratification. This view is completely unfounded and nonsensical. Article 5 is a part of the Constitution. The Convention of States is one of two methods for amending the Constitution. Under both methods, 3/4 of the states must assent to the adoption of an amendment for it to be effective. As the 3/4 requirement is a part of the Constitution, that requirement can only be changed, amended, pursuant to the existing terms. If a convention were to circumvent Article 5's requirements for amending Article 5, why would they respect any other ratification requirement for a proposed amendment? Moreover, given that the purpose of the convention is to limit government and redress the overreach by the federal government, such impudence would not likely be tolerated by the states.
Have you seen the pictures on television of the tens of thousands of demonstrators at the Wisconsin State Capitol who are protesting any cuts in the benefits for state employees? Well, if you've seen that, you've had an advance peek at what you would see if we ever are so foolish as to allow state legislatures to call a new convention to consider amendments to the Constitution.
Ms. Schlafly refers to the mobs of protesters who occupied the Wisconsin state capitol and conjures up such a scenario surrounding a convention of states. As unpleasant as the protests may have been, the fact is that the Wisconsin legislature passed the legislation against which they protested. The governor subsequently survived a recall election and was later re-elected. If anything, this experience is more evidence in support of a convention because the Wisconsin legislature was not hijacked under the very circumstances she predicts for a convention of states. Edmund Burke said, "The only thing necessary for the triumph of evil is for good men to do nothing." We are Americans. We have the power to determine our future. We can do it, and we must do it.